So we're going to go ahead and get started here today. I want to welcome everyone. We're having a beautiful day outside. It looks like the clouds are going to break. Not too hot yet here in Atlanta, Georgia. Today's a very exciting day for us because we're welcoming our new law partner, Scott Fields. Scott, you might be able to see him. He's got his bow tie on there. Looks very academic. Just so you know, Scott's going to be joining the trio now that includes myself and also Lynn Bittner. Everybody, please take note. Lynn is not going anywhere. He's here. He'll be here. We've got enough formaldehyde to keep him around for decades yet. So we love Lynn, and he's not going to go anywhere. So Scott's just been helping us out because our workload is increasing thanks to you and your wonderful, kind referrals. You know, the Magellan Planning Group is basically consisting of the legal, financial, and the tax all together, and the coordination between these through entities and these through three divisions is really important, these disciplines. So that's why we needed some help on the legal front, and I'm happy to welcome Scott Fields. He actually lives in Tucker, has 4 sons between, I think, 18 and 23-ish. And so he's definitely been through the ringer. And I know he's from, actually, speak of the ringer, he's from my old alma mater, Georgia State University College of Law. So he had a lot of the same professors that I had. And I know he suffered like I did. So he made it through. And that's how we know we can depend on him. So I'm not going to belay it anymore. I just want to welcome everybody. It's great to see you partially. I know some of you are out there. And we hope to be back in the room downstairs, maybe in the third quarter. So we're just taking it, you know, day by day. And as soon as our building lets us welcome you back into the conference area, the classroom downstairs, we'll start doing those downstairs as well. And we'll probably continue to do these webinars because they seem to be pretty popular. But without any further ado, I'm going to go ahead and sign out and welcome Scott. Scott Fields, everybody. Thank you very much.
Thanks, Kevin. I appreciate the introduction. Like I said, my name is Scott Fields. I'll do a slightly longer introduction here in just a few minutes. I'm also going to go ahead and share the screen, which is the presentation slides that we've got. I'm not quite sure whether you'll continue to see my face, so apologies if you do. We're trying not to. So let's see. I want to make sure that we've got everything correct. All right. So what we're talking about today are estate planning documents. You've probably heard some about estate planning and estate planning documents. You've probably heard some about these documents themselves. And what I'm going to do today is just do a brief overview of the 4 main estate planning documents that are out there. So let's go ahead and get started. All right, so because I'm a lawyer, I have to do a little disclaimer. Watching this presentation does not make me your attorney. Watching this presentation does not make you my client. You'd be surprised at when people will claim that someone is their attorney or that they are someone's client. I had a family member who kind of emailed me out of the blue, letting me know that he'd been telling his HOA that I was his attorney for quite some time. And I had to tell him that no, that was not true. This presentation is not legal advice. And this presentation, the information in it only applies to Georgia. If you are in another state, or if you leave Georgia for some reason and go to another state, this information may no longer be valid. All right, so a brief outline of what we're doing today. I'll do an introduction. We will talk about the 4 main estate planning documents. We'll talk a little bit about when to get them. And then at the very end, we'll have a time for questions. So down at the bottom of your screen, if you kind of hover over your screen, you should see some little buttons down there at the bottom. And one of them says Q&A. So if you would, please, if you have questions, please type your questions. Click on the Q&A button and then type your questions in the box that shows up. We will go through all the questions at the end. And then we'll try to make sure that we get all of them. And if we can't answer all of them, then we'll set up a time perhaps to answer those questions individually. Okay. So who is this guy? As Kevin's already said, I'm an attorney. I've been an attorney for almost 10 years now. Formerly, I was a real estate litigator, and now I mostly deal with probate and real estate. I attended Georgia State University College of Law, as Kevin said. Before I became a lawyer, I worked in IT and education. I have been married for about 26 years to the same person. It's quite an accomplishment. I have 4 sons, 23 to he's 17 for a few more weeks. He turns 18, which he's very excited about telling us about all the time. I'm almost a native of Atlanta. It's a long story. I've lived in Tucker for about 22 years. I do have one dog and one cat. We picked up the cat in 2020 as a mental support animal. So let's talk about the four main estate planning documents. The first is the last will and testament, which I'm sure you have all heard about. The second is a power of attorney. The third is the advance directive, and the fourth is a trust. We're going to go through all of those at a relatively high level. So let's get started. So the first document that we're talking about is a will, or a last will and testament is the long term. And as you may already know, a will allows the person making the will, who's called a testator, by the way, in case you care. A will allows you to decide who gets what out of your assets, out of your estate, who doesn't get anything. Georgia allows you to disinherit people, including children and spouse, from your will, although it can get complicated in terms of a spouse or a minor child. The will allows you to decide who manages your estate, who carries out all the acts and things that are in the will. That person is called the executor. So why get a will? Well, without a will, the law determines who gets what out of your estate, and that law is OCGA 5321. If you want to go look it up, and it basically is a list of who, in what order, receives assets from your estate, and kind of in what proportions do those people receive things. So the first layer is spouse and descendants. Descendants is your children, if they're all alive. If one of your children has predeceased you and have their own children, then it's your grandchildren through that predeceased child. A lot of people think that if you die and you're married and have children, that your spouse gets everything. That is not true. We hear that a lot, actually. So if you have children and you would like for your spouse to get everything instead, you need a will. Because if you don't have a will, then by law, it gets divided up among your spouse and children. If you just have a spouse and no children, your spouse gets everything. If you just have children or descendants and no spouse, then your descendants get everything. If you have no spouse and no descendants, no children, no grandchildren, anything like that, then under Georgia law, it goes up to your parents. If one of your parents is predeceased, then it goes to the remaining parent. If you have no parents surviving when you pass, then it goes out to your siblings and to their descendants. So again, if there's a predeceased sibling, it goes down to their children and things like that. So it's possible for nieces and nephews, great nieces, great nephews, things like that, to inherit from your estate without you doing anything. If you have no siblings and no descendants, it goes up to your grandparents, and then it goes out to your aunts and uncles and their descendants, and so on and so on. It's a really interesting chart that goes up and out and up and out and up and out. Georgia does not have a cutoff. Some states will cut off at some degree, second cousin, third cousin, that sort of thing. Georgia does not. Georgia, we will go out to 17th cousin if that's a person who is identifiable, and if there's nobody closer. So that's something about Georgia, is we try really, really hard to try to find an heir if there's not someone who is one of those earlier stages. As you can see, these are in a priority order. If there is someone in a certain level of priority, nobody underneath that priority inherits. So for example, if you are married and you pass, then your parents, siblings, none of those people inherit anything. The other thing to remember is that without a will, it is only blood relatives, with the exception of your spouse. So if things would go to your children, for example, but one of your children has predeceased and they were married when they died, well, their surviving spouse doesn't receive anything unless you have a will and want them to. Without a will, it's blood relatives only. Okay, without a will, other things that could arise, anybody can be the administrator of your estate. You don't get to choose. It can be a family member. Most of the time it is a family member. That's most of the administrative estates that we deal with. But it could also be a creditor. A creditor is someone that you owe money to. One of the things that we see a lot is where a person will pass and there's an HOA lien against a house or a condominium that they have. And the family will not probate the estate. They'll just sit on it because they don't want to have to deal with the lien. And I've had HOAs come to me and say, we need to get someone appointed to administer the estate so that we can force the sale of the house and recover on the lien. So any creditor can do that. They can go to the court and say, hey, look, the family's sitting on their hands. We need to get an administrator appointed so we can deal with this debt. And then the last is a county administrator. The court can appoint a neutral third-party attorney to act as the administrator for an estate. And that's if no administrator can be found, for anybody else, or if there's a conflict in the family. So I've had to deal with that a couple of times where one family member says, I want to be the administrator, and another family member says, no, I want to be the administrator. And usually what happens in that situation is the court will appoint a county administrator, and they do get paid to do that job. Finally, without a will, your estate can be more difficult to deal with. By default, Georgia law requires that the administrator post a bond for the full value of the estate. It's very rare for a court to waive that bond. A bond is like an insurance policy. So if there's a $3 million estate, they don't have to pay $3 million somewhere. They go get a bond, they pay a premium of a few $1,000s for the bond, but it's still a pain in the neck. It takes, it adds an extra week or two to the process, depending on where you get your bond from, and it costs money. I mean, that money comes out of the estate, but it can be a pain in the neck. Inventory and returns, speaking of pains in the neck, if by default, if the will does not waive it, then the court will require the administrator to file an inventory with the court, which is kind of a snapshot of what the person owned when they passed away. And then annual returns, which is just like an income tax return. It is a yearly statement, year-long statement of what came into the estate, what went out of the estate. You're paying debts, you're selling a house, you're dispersing money to heirs, that sort of thing. And then finally, and this is the biggest problem, if there's an administrator without a will, and if the stars don't line up just perfectly, the court will require a second petition called a leave to sell in order to sell real estate. And that adds many, many more months to a probate because an administrator does not automatically have the authority to sell real estate. They can do a lot of things, but not real estate. And you have to file a petition for leave to sell. And we're doing a couple of those, and they are some of the longest estate cases that I have right now involve petition for leave to sell. Will waives all of that. With a will, you get to decide who receives what from your estate. You get to decide who doesn't receive anything. You get to decide who your executor will be. And finally, you get to decide how easy to make your estate. A will can waive the bond. A will can waive inventory and returns, and a will can grant the authority to sell in the will itself. So it can really make things go much, much more smoothly. The second document that you may have heard of is a power of attorney, or a POA. Power of attorney basically grants authority to someone else over your assets. A financial power of attorney grants authority over assets. It's your property, it's your finances, it's your stuff, to use a non-legal term. That other person that you grant authority to is called an agent, or sometimes an attorney in fact, is an older term. Sometimes people will call the person a power of attorney, which is technically not correct, but it's fine. We're not going to make fun of you if if that's what you call them. But on the forms themselves, they're called the agent. On older forms, they're called attorney in fact. All of those are correct. There are a couple of different types of powers of attorney that you may have heard of. One is durable. We get people calling our office a lot of times asking because they want a durable power of attorney. What durable means is that if you make your power of attorney document while you have capacity, mental capacity to make a power of attorney, which by the way is the only time you can make one. If you are not mentally capable, if you're incapacitated, you cannot make a power of attorney for relatively obvious reasons. But you make the power of attorney while you are mentally competent. And then if you then become incapacitated, if you're unable to make or to communicate financial decisions, then the power of attorney stays in force. We instituted a durable power of attorney because it used to be that at the moment you became incapacitated, the power of attorney went away, and which kind of gets rid of the whole point of having a POA in the first place, but it is what it is. So a durable power of attorney lasts throughout your entire life. The second type of power of attorney is a springing power of attorney. Whereas a durable power of attorney usually takes effect immediately, most of the time, a springing power of attorney doesn't take effect immediately. You sign it tomorrow, and then there is a trigger. And when the trigger happens, that's when the power of attorney comes into effect. 99% of the time, that trigger is incapacitance, right? As soon as a doctor swears an affidavit or just writes a letter that says, hey, this person is incapacitated, they're no longer able to make or communicate financial decisions, well, that's when the power of attorney kicks in. But the trigger could be anything. The trigger could be, if you dye your hair blue. The trigger could be if you move out of this house and move into another house. The trigger could be you sell your car. I just did a power of attorney for a lady who travels a lot. And the trigger that we put in was incapacitance is one. The second trigger was if she is out of the country and if she is unable to be reached within a reasonable amount of time, then the power of attorney kicks in. So again, a trigger can be almost anything that's legal, but most of the time it is mental incapacity. More about the power of attorney. Format, what will a power of attorney look like? Well, the picture there is the new form, which came into play in 2017. Before 2017, most attorneys kind of homebrewed their own. They look a lot like a will. They can be very, very long. They can be very, very comprehensive. Most of the time they said mostly the same thing, but they could vary in certain things. And so that's what you can always tell if you've got a pre-2017 power of attorney, if it's really long and looks like a will. In 2017, the state of Georgia, the legislature created a standard form. It's called a statutory form. You can see on the picture. What that means is that the text of the document is in the statute itself. You can go to the law books if you happen to have a bunch laying around, and you can look up the text of the statute. They revised the document in 2018 to fix a couple of problems. So if you have one that is from 2017, or if you're unsure, just give us a call and we can tell you which one you have. But one from 2018 is a little bit easier to deal with, especially in terms of revocation. It is a standard form. The text of the form is found in OCGA section 19.9.134. You can download these from a lot of different places, including the Department of Public Health. I think you can get these. However, they are a little bit tricky, and it is easy to make a very, very powerful and important mistake. So just like deeds, I don't recommend you do these yourself. At least talk to an attorney and have them explain it to you. All right, more about the power of attorney. Without a power of attorney, nobody else can access, manage, sell, close your assets. Your assets are basically kind of in limbo until someone receives the authority to deal with them. And most of the time, that authority either comes from a power of attorney or from the court itself. So if there's no power of attorney, then the court will have to step in and appoint a conservator. That's a long and potentially tricky process. It costs money. It takes weeks at a minimum in order to deal with those sorts of things. And so we recommend highly and very strongly that you get a power of attorney instead, because your conservator could be anybody. I have seen distant and kind of absent family come in to try to be appointed as conservator. I have seen home healthcare workers come in and try to be appointed conservator. That's rare, but I've seen it. I've taken that to court. So if you want a particular person, if you want to grant particular authority, get a power of attorney. With a POA, with the power of attorney, the court generally does not get involved. You just get the power of attorney, get it signed, get it notarized, make all the selections you need to make, and then you just give a copy to your bank, to your financial institution, to a closing attorney, financial planner, any of those folks. Okay, that's the power of attorney. Let's talk about the advance directive. Georgia Advance Directive for Healthcare is actually the full title. We just call it the Advance Directive. What the Advance Directive does is it combines and replaces a bunch of documents that you may or may not have heard of before. The healthcare power of attorney, a living will is included, the nomination of guardian form, and a HIPAA release. All of those are included in the Advance Directive. So if you have older documents, or if you have those documents separately, then you may want to consider getting an advance directive, because it is a standardized form. We'll talk about that in a second. But this one document has all of them in there. Okay. Generally, an advance directive appoints one person or a couple of people, if you'd like, to make healthcare decisions on your behalf if you are unable to make or to communicate healthcare decisions on your own. It also allows you, like in the living will, to make certain choices in advance about what you want for end-of-life healthcare and for what you want in terms of things like burial and cremation. So you can go ahead and tell people, I would like to be cremated. I would like to be buried. I would like to have this type of funeral. Those sorts of things are all things that you can put into an advance directive. Okay, more about the advance directive. What you see there on your screen is the first page of the standard form. This form came into being about 2007, excuse me. Before 2007, you had, there was no standard form. So you had those 4 documents. Some people may have just 1, just 2, and they could look like anything. Again, healthcare power of attorney could look a lot like a will because people just kind of made them up and wills are what they were used to making. In 2007 until now, we have the standardized form. All of those things are combined. And the text of that form is in OCGA section 3132.4. I will go ahead and tell you, if the power of attorney is a little complicated, the advance directive is much, much worse. It can be extremely confusing. There are places where you initial to grant someone authority. There are places where you initial to take away authority from someone. It's written by legislators who I'm sure they have many, many things that are good, but not the clearest people when it comes to legal and healthcare forms, frankly. That's just my opinion. Without an advance directive, your family can possibly have some authority to make decisions, medical decisions on your behalf, but it's limited and it can be confusing as to who is going to do it. But generally what happens is the court has to step in and appoint what's called a guardian. If a conservator is the person who the court appoints to deal with your assets, with your stuff, a guardian is someone that the court appoints to deal with pretty much everything else in your life. Where you live, medical decisions, who can come and see you, what you eat, those sorts of things. Those are all handled by a guardian. If a conservatorship petition is kind of difficult and takes a long time, guardianship is even worse. Because with conservatorship, you're just talking about stuff. With guardianship, you're talking about the person themselves. And courts are not in a hurry to take away someone's rights and give those rights to someone else on your behalf. But with an advance directive, the court generally does not have to get involved. Again, you get this document created, you get it signed and filled out properly, and then you just give it to your healthcare providers, to a living facility if that's where you live, give it to all your doctors. Send a copy to your health insurance company. If you go to a new doctor or a new healthcare provider, they will probably ask you if you have an advance directive. So you may start seeing those questions coming up more and more often. Along with the advance directive, there is one additional document. It's called a POLST, a P-O-L-S-T. It is a physician's order of life-sustaining treatment. The POLST is a new document for Georgia. It's pink. It's hard to mistake it. It's a big pink sheet of paper, and it's printed on both sides. It is limited to just a few questions, so there is a little bit of overlap with the advance directive. For example, CPR is covered in both documents. But whereas on the advance directive, it's very binary, CPR yes, CPR no. The POLST gets a little bit more granular. There's some situations yes, some situations no. Some situations, it's kind of at the discretion of the healthcare provider who's there. So what you do is you get a POLST and you take it to your doctor the next time you go see them, and the two of you go over it together, you initial check mark things, and then both of you sign it. So because it is a physician's order, it is supposed to have a little bit more weight than an advance directive, although both of them are supposed to be perfectly fine and legal. The POLST, is the top among potentially equals. How's that? All right. The last document we'll talk about is a trust. So trusts are extremely versatile and extremely powerful. It is hard to find something that a trust can't do in terms of managing and protecting someone's assets. I'm going to go at an extremely high level talking about trusts in general. And then Kevin is the expert on various different types of extremely powerful trusts for, tax liability purposes and things like that. I'm just going to talk about what a trust is and some basic parts of it. So, as I said, a trust is extremely versatile and powerful. A trust is an entity that can own things. So in that sense, it's a lot like a corporation, right? Coca-Cola owns a building downtown. That building is not owned by any of the shareholders who own shares of Coke stock. If you own Coke, own some shares of Coke stock, you do not own that building. If someone slips and falls in the Coca-Cola building and they sue and win a judgment, they cannot come after you as a shareholder because it's the entity that owns the building. They can only collect from that entity. In the same way, a trust is a thing that can own things. If a property is in a trust, let's say, for example, I put my house in a trust and then rent it out to someone, and then there's a slip and fall and they sue and they collect a judgment, they can collect against the trust and its assets, but not me, because I'm not the owner. I'm not entitled to that asset. The title to the asset is owned by the trust. Okay, so a trust protects the assets from a variety of different things. Beneficiary, we see trusts set up for children, for example, or for siblings in some cases, where you want to provide for them, but you don't want them to waste the assets, right? Like I mentioned, I have 4 sons. I would not give any of them $100,000. Would I like for them to have $100,000 available to, for example, buy their first house or to start a business? Sure. But I know that if I gave a bunch of money to them, there's a good chance they would go buy guitars, is actually the current thing. So you can protect assets from the beneficiary, from the person who's supposed to be able to use the assets. You can protect assets from certain creditors, which means, again, if I put $100,000 into a trust for one of my children and they go and they get one of those credit card applications that everybody gets their first year of college, they run up a massive credit card bill, don't pay it, get sued. The credit card company cannot come to the trust and collect from the assets in the trust. They can only collect from my child because my child doesn't own the assets. It's owned by the trust. And then finally, a trust can protect assets in some cases from probate. Again, because in probate, what's happening is you have creditors who are coming and asking for assets from the estate after someone has died. And a trust can move those out because, again, the only assets in general that are collectible are assets that are in the name of the person. If those assets are in the name of a trust, the creditors don't have access to them. In general, it's law, so of course there are exceptions. So let's see. More information about a trust. Who are the people involved? There's several people involved, and every trust has all of these. They're given names, which can be confusing, but we're going to explain them. So generally, the first person is called a grantor, and the grantor is the person who puts assets into a trust. If I put my house into a trust to protect it from somebody suing me, I am the grantor. They used to also be called the settlor, and we don't use that term anymore because it's hard to say and it sounds weird. But the grantor or the settlor is the person who puts assets into a trust. The second person is a trustee, and a trustee is a person who manages the assets in the estate. So again, if I put my house into a trust, I will appoint a trustee, and that trustee is the person who's responsible to pay the real estate tax, to make sure the grass is cut. If there's a hot water heater that bursts or something like that, the trustee is the person who handles all of those things. If the property needs to be sold and then another property purchased with those same assets, the trustee is the person who has the authority to do all of those things. The grantor and the trustee can be the same person. A lot of times when we create a trust to hold real estate, just kind of a basic real estate trust, the grantor and the trustee are the same person, right? I'll put my house in a trust. I will nominate myself as the first trustee so that I can continue to make decisions about, do I want this house? Do I want to sell it and buy another house? All those sorts of things. But it also can be another person. It can be anybody else that you would appoint. The third person in a trust is the beneficiary, and the beneficiary is the person who receives the benefit of the trust. So if we talk about the trust of putting money into a trust for my child, then I would say, I'm putting $100,000 into a trust for my child. They can take money out to start a business, to pay for school, things like that. That makes my child the beneficiary. If I put my house into a trust and then I want to live there, then I am the beneficiary of the trust because I get to use the asset. If I put the house into a trust and then say that I want my wife to live there, then she's the beneficiary of the trust. We could both be beneficiary. You can have multiple beneficiaries. You can have multiple trustees and grantors. There's really not a limit other than practicality. So again, the grantor, the trustee, and the beneficiary can all be the same person. I can put my house in a trust. I can nominate myself or name myself as the trustee to manage that. And then I can also be the beneficiary as the person who is able to live in the house. And if I rent it, I can receive income from it. You do have to be careful when you're naming the same person as trustee and beneficiary, because if you don't include kind of some magic language in the trust, then the trust could evaporate. It just kind of collapses in on itself. But a good trust is set up and includes that language so that that doesn't happen. And I won't go into the details here just because it's law and I don't want to bore you. It also takes time and we don't have that much more time. A couple of types of trusts at a very basic level. You may have heard some of these terms related to a trust. So the first is revocable versus irrevocable, or irrevocable, depending on where you're from. Revocable trust is a trust where the grantor retains the authority to modify the trust. They can change the rules, or they can simply revoke the trust entirely. I put my house into a trust and it sits there for a few years and I decide, nah, it's a pain in the neck. I don't want to deal with it. Or for some other reason, I want to revoke the trust. Then I revoke the trust and the property goes back into my name. Okay. Irrevocable means that the grantor cannot make changes to or revoke the trust. Once the property is put in the trust, it is essentially gone. An irrevocable trust can also have the grantor as the beneficiary. I could put my house into an irrevocable trust, name myself as the beneficiary who can live there during my life, and make the trust irrevocable so that I can't, end the trust or make modifications to it. Irrevocable trusts are used a lot of times for tax liability issues, especially for estate taxes. And again, that gets extremely complicated. It is not enough to simply say that a trust is irrevocable in order to deal with tax liability issues. There are some additional things that the IRS wants to see that you have to put in there. And I am not going into that because that is way too complicated. And that is more in Kevin's line. The other thing that you may have heard of is a living trust versus a testamentary trust. Living trust is sometimes called an inter vivos trust. Inter vivos is just Latin, means during your life, or that's close enough. A living trust is made while you're alive. A testamentary trust is made in your will. That's a testamentary trust, or it's made after you have passed, usually in a will. So is it possible to have a revocable living trust? Yes, because you make a trust while you're alive, that makes it a living trust, and you put language in there that allows you to revoke the trust or modify it, and that makes it revocable. All testamentary trusts are irrevocable because when you die, you can't make any changes to your trust, and that's just the way it is. So those are kind of the main terms. There are a lot of other terms for trusts that, again, Kevin can explain and go over those with you. Finally, without a trust, the assets that you own are owned by you. My house is in my name. It's actually my name and my wife's name. But my house is in my name, which means that it belongs to me, which means that it is available to my creditors. If I go out and go crazy and run up massive credit card bills and can't pay them off, then the credit card companies can sue me, win a judgment, and sell my house to pay themselves off. Without a trust, the assets that a person owns when they die must go through probate. And again, there are some exceptions, but in general, those assets have to go through probate. Okay, so get a trust, or a trust can protect your assets from all sorts of things. And that's usually what they're for. All right, last bit. Finally, when do you want to consider getting these estate planning documents? There's kind of 4 basic scenarios. The first one is if you have some documents, but they're from another state. You have a will, but it was made in Kansas, just to pick a state out of thin air. You have a financial power of attorney, but it is from Maine. Those documents may or may not be valid here in Georgia. And it is usually just as easy to go and get new ones as it is to pay an attorney to go through line by line to look at your old documents and look at your look at your old documents and compare them to Georgia law to find out if they're valid. If you create a set of documents in Georgia and move somewhere else, you'll probably need to get those done somewhere else, have them redone in a new state. We tell our clients, always get new documents when you go to another state. Is it possible that there are states where Georgia wills or other documents are accepted? Possibly, but that's not a risk I want to run. If you have documents that were made by a non-professional or that were downloaded from the internet or copied from someone else, or if you just sat down at your computer one day and hand wrote some, just made some up based on something, some research that you had done, I would strongly suggest having someone take a look at those, having an attorney, a probate attorney. Another thing that we see sometimes is attorneys who are not probate attorneys will create these documents. And that can be okay, that cannot be okay. If you get a DUI or if you want a divorce or if you want to do a complicated trust, for example, don't call me. That's not my area of specialty. If you want to create a complex trust, if you want to do a will, or even if you want to go through an advance directive, you may want to talk to a probate attorney rather than a corporate attorney, just because different people have different experience. And like I said, I have done some litigation, so I have seen what can go wrong with these documents if they're not done properly, and a lot can go wrong. Let's just put it that way. All right, so if you have documents that are old, you probably want to consider getting newer versions of them. So for example, if you have a document that's titled a living will or a healthcare power of attorney, you probably want to look into getting an advance directive, simply because older documents may cause delay in getting the care that you need or being able to do the things that your family needs to do in order to take care of you. The advance directive and the power of attorney form are standardized. If you take an advance directive and give it to someone at a doctor's office, they should know exactly what that is and know what to do with it. If you take the Georgia standard form power of attorney to a bank and you hand it to them, they should know what it is. The problem that we used to have is we'd have these homebrew powers of attorney, the real long ones that said all sorts of things in them. We'd take them to a bank when someone was incapacitated, and the bank would say, great, we need to run this up to legal. We'll call you in a couple of weeks. And then legal may or may not say that they liked it. And that's a problem. So if you have older documents, you probably want to consider looking into getting newer versions. Okay, at least talk to an estate planning attorney just to see whether or not something you want to do. And then finally, you want to consider getting estate planning documents if you don't have any, or if you don't have one of these, right? You have a will, but you have no power of attorney. You have a will, but you don't have an advance directive. We saw a lot of this in 2020 during the pandemic. A lot of people called us wanting to get advance directives, which is a great idea, so that there was somebody who could make healthcare decisions in case someone was incapacitated. Again, we've kind of gone through in all four documents what happens if you don't have any of them. I think the biggest issue is you don't have any control. And so a lot of things can happen that you never anticipated or maybe never wanted to have happen. Okay. So in summary, the four estate planning documents are a will, power of attorney, advance directive, and then the post as well, and a trust. And then we talked a little bit about when you should get those documents and the conditions. And this will be available for some people, or you can just contact our office and we can tell you more about those. And then finally, questions. So I've seen 2 questions come in on the Q&A. Again, if you have Q&A, go ahead and just kind of go to the bottom of your screen, just kind of mouse over down there at the bottom, and the little buttons will pop up and one will say Q&A. So the first question I have is, if you have set or will trust in one state and move to another state, does the will or trust need to be redone? So the word need in there is kind of gives me a little bit of a pause. So it is possible that a will or trust created in one state is not valid in another state. You should have an attorney in the new state where you reside take a look at those documents and let you know whether or not they're valid. Just because something is valid in one state does not make it automatically valid in another. And just because something is valid in one state does not make it automatically invalid in another. So for example, Georgia wills have a very basic set of requirements in order to be valid. In Georgia, a will is valid if it meets 3 requirements. It has to be in writing. It has to be signed by the person making the will, called the testator, and it has to be signed by 2 witnesses. And the witnesses and the testator have to all be in, it's called in the presence of, they have to all be, basically they see each other. You want everybody in the same room, or at least in line of sight. There's some old cases about what happens if they're in different rooms, but they can see each other through the hallway. But basically, as long as a will meets those 3 requirements in Georgia, it's a valid will. Is it possible to have a will from another state that is written, signed by the testator, and signed and witnessed by 2 witnesses? Yeah, it is. And in that case, that will would technically be valid in Georgia. But I've seen wills that have 3 signatures, and they're from a state maybe that required 3 signatures. I've seen wills that have 1 signature. And so if you have a will, let's pretend that Indiana, let's pretend that Indiana only requires 1 signature for a will, 1 witness. Well, if you bring that will to Georgia, that's not a valid will. Okay. So a trust, again, it's a little more complicated about whether they're valid. If you have moved from one state to another, I would talk to an estate planning attorney about whether or not you should get revisions of those documents. That's probably the best answer I can get. Let's see, next question. Can there be joint control and power of attorney? Yes, you can have multiple people be your agent in a power of attorney advance directive. You can have multiple people be your executor in a will. You can have multiple people be a trustee. Those are called fiduciary roles, by the way. Yes, it is possible. I normally don't recommend it except in very specific cases where it is okay. The problem is that it adds time and potentially adds conflict, right? I have 4 sons. Let's say, for example, I wanted to make all of them my agent on a financial power of attorney. Well, that means that all of them have to agree and all of them have to be available to agree in order to make a decision. And so I've had situations where we have co-executors who don't get along, they don't agree. And there's no tiebreaker provision that's put into the will. Whenever I make a will that has multiple executors, I will usually try to include a tiebreaker provision. And it could be something like flip a coin, pull a card from a deck, get a neutral third party to decide, all sorts of things. But it can be complicated and it can take more time if one of the people, for example, lives out of state and you're not able to reach them easily. So I don't normally recommend it, but yes, it is possible. All right, let's see. Third question, when presenting power of attorney documents to healthcare bank officials, must the document be original and notarized or can it be a copy? All right, so let's deal with the notarization first. Power of attorney has to be notarized. An advance directive does not have to be notarized, so you don't have to worry about those things. As for being originals, everybody is supposed to take copies. That's the law. Under Georgia law, people are supposed to accept copies. Now, does that mean that people aren't going to ask for the originals? Sure. And just between you and me, it's banks is where we run into this problem the most often. So they will say, whether it's a bank or a healthcare provider or some other financial institution, they'll say, hey, copy looks great, but I'm going to need that original. Well, you could fight them and you could sue them to force them to accept the copy, or you could just take the original. The one piece of advice that I give to people if they take an original someplace is take the original, do not leave without the original, right? Have them scan it in, have them approve it, have them do whatever it is they need to do in order to confirm that they have seen the original and then leave with it. The only reason I say that is because I've had a couple of situations where someone will take the original someplace and keep it. And then I had a situation where someone sent an original one of these documents to a financial institution. The financial institution never returned it. And then after 90 days, their policy was to shred all documents. And so, of course, they shredded it. And then due to other circumstances, that added 6 months onto the estate. Huge, huge pain in the neck. So if you do have to take an original, if you're asked to take an original and it's just easier to do it than argue, take the original. Don't walk out of the building without the original in your hands. I hope that explains that. Let's see. Question number 4, what is the approximate cost to have these docs updated? Someone says we already have them, but they are old. So that is going to depend on a case-by-case basis. It depends on what you need. It depends on what you do. So, there's a most people will have a base cost for a, kind of a basic set of wills or a basic power of attorney. And then those things, those costs can increase depending on whether or not you, what kind of changes you want to make. I have dealt with wills where I had people who wanted to give, I think it was costume jewelry to granddaughters. And what happened was we kept getting requests to change the method by which the granddaughters could choose the costume jewelry. And they changed it 3 or 4 times. Well, for those sorts of changes, at the time, I was charging, I billed hourly for modifications once people started coming back. So that increases the cost. But it just kind of depends. I'm sorry, I can't answer that question. If you want to find out what Magellan's costs are, you can look at our website or you can contact us, and we can give you a kind of a good idea, an estimate at least of what it's gonna stop. Let's see. All right. Oh, this is a good question. Are adopted children considered blood for probate purposes? If they are legally adopted, according to these, the standard definition under Georgia law, then yes, they are considered blood for probate purposes. In terms of inheritance, right? So there's a parent, they have an adopted child, the parent dies, and that child is considered a child for whether it's under the will and the will just says my children inherit, or whether there's no will and the child is then a legal heir. Where it gets difficult is when it comes to a parent, whether it is an adopted parent or a biological parent of an adopted child, inheriting when that child dies. That has some complications to it. It's a whole other issue. It's rare, and I don't have the time to go into it here. And I would actually have to look up a little bit of that in the book, because I know some of that, but I don't know all of that. So, but in terms of inheriting downwards, inheriting from a parent, yes, an adopted child, if they are legally adopted, is a relative blood child, a natural child, as they used to say, for probate purposes. The problem comes is that in a lot of situations, the child is not legally adopted. They are raised for all intents and purposes by someone. We see this a lot with like grandparents raising children, or aunts and uncles raising nieces and nephews. And the child may spend their entire life, and this other person treats them just like their own child. Legally, is that child a child of that person? If there was no legal proceeding and no order making that child adopted, it's maybe, but probably not. It's very, very hard to do. It's called equitable adoption, and it is really, really difficult to get a court to recognize that. Okay, let's see. Will this good presentation be available online to help educate children, grandkids on the importance of these documents? Yes, I believe it will, and thank you for your kind words. I appreciate it. I hope it's good. But yes, this will be available. We have a YouTube channel, and this will be there along with Kevin's other presentations. How do ex-spouses fit into the probate with and without a will? All right, let's talk about without a will, because that's easy. If legally divorced, right? If you are legally divorced, your ex-spouse is not a legal heir. So if you are legally divorced and don't have a will, your ex-spouse does not inherit. Only current spouses and children, well, let's just talk about spouses. Only current spouses are legally heirs. Okay, that's the easy part. If you are in the middle of a proceeding to get divorced, it's a little bit fuzzy, but generally, until there's an order of divorce, that spouse is still a legal heir. Again, there are some situations where that may not be true, but in general, even if you're in the middle of a legal proceeding, that person is still a legal heir. For wills, it kind of depends. A will can, for example, if a will says my spouse inherits everything, or if a will says I'm married to, my wife's name is Christy, Christy Fields receives everything. As long as we're married, that's fine. If we get divorced, Georgia law gets a little complicated as to whether or not she would still be included. If there is language in the will that says that the will is made in contemplation of divorce, for example, then it's possible she would still continue to inherit under the will. It's possible that she would not. So it just kind of depends on what the will says. The will that I use actually specifically says that any assets or any authority given to Christy Fields, under this will is conditioned and predicated upon the fact that we are still married at my death. If we are not legally married at the time of my death, then she does not receive any assets and she does not receive any authority. So my will that I make specifically says that, but whether or not an ex-spouse has it under a will that that you may have is going to depend on the language that's in the will. It's not an easy thing to determine. So I apologize for that. And that is all the questions that I have in the Q&A. I want to leave this open for just a few more minutes. We got about 9 minutes left on our hour. If anyone else has any other questions. And I'm used to just looking out in an audience and pointing at people, but I'm having to look at this screen over here to see if anybody else has any more questions. Okay. Well, at this point, unless someone is in the middle of typing, which I can't see, I'm going to go ahead and end the presentation. If any of you have any questions, you can send an email here. My email is Scott, I think that's right, scott@magellanlegal.com, and I'll have to double check on that. But you will also have Kevin's and Kristen's email, or you can just respond to the email that contain the information about this presentation. You can also go to YouTube channel, our website. Our email addresses are all over the place, and so you should be able to get in touch with us. If you have to send an email to someone who is not me, just say, hey, I've got a question for Scott about his presentation. He forgot to tell me something. Okay. Thank you so much for your time. I really appreciate it, and I look forward to talking with y'all soon.